and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And indeed, as always on a Tuesday morning, we have a real good one. David Whiting, good morning.
Good morning, Ali.
Look, last week you were able to be in the naughty corner. Today, no. Back to being ostracised.
I live in a hot spot, and I'm trying as much as I can to give effect to the Premier's if you can do it from home, do it from home. So I'm doing it from home.
No, excellent. We're very pleased you're doing it from home, but we miss you. And it was delightful to have you in here last week. It gets very lonely, you know, being in a studio with no guests. I mean, I've got plenty of guests, but not anyone actually to talk to.
Understood.
Physically.
We'll see what happens next week. Yep.
We will. It's a week-by-week proposition. Now, you did have a little bit of homework.
I had a little bit of homework from a gentleman by the name of Dimka. He was at Mernda, lived in Mernda, and he had been showing symptoms of something, so he went to the doctor. He had a COVID test and was told to isolate until the results of the test were available.
He was symptomatic or asymptomatic?
He would have had a cough or a cold or a sniffle or a runny nose, or we didn't get into the detail. And as happens is you have the test and you're told to isolate until such time as you have results. And he did not, thankfully, have COVID, so he was able to go back to work. And the question was, well, who's going to pay him for the period when he wasn't working? And the answer is nobody is. In the same way as self-employed people don't get paid in those circumstances. You're unable to go to work because of the health direction. If you had been found to have COVID and you were a close contact, then you're entitled to a degree of compensation from the state government of $1,500. But if you don't, that's, in a sense, that's part of the price of living in a community. In the same way as we'd like other people to do the same for us, they expect us to do that for them.
It's tough though, isn't it? Given some people are getting their results in 24 hours, other people, and particularly the ones who are texting, are getting their results in, or not getting the results even 7 days later.
Well, I was listening yesterday afternoon and there was somebody 10 days they'd been waiting, and they were told that
that's
that
ridiculous,
really meant
isn't it?
10. It's just way out. I had mine done. Because I live in a lockdown suburb, we've all had them. 3 people in this house. Mine took from a Friday to a Monday afternoon, which I thought was fantastic. And my wife and daughter got theirs the day following. So we're not complaining about the delay. But because of the number of tests, they'll use different labs and people have different time frames.
But it does seem to be more, and this is a good thing, it seems the longer ones seem to be more the exception than the rule. But you'd think that if it's 10 days, potentially something's gone wrong, I guess. But look, we're not experts in the testing time, so I suppose it's more that if you've got to be 10 days with no income, then that is obviously pretty onerous. Border crossing, that's obviously the new news since we last spoke to you. From a legal point of view, that also is just a case of, well, you bear the cost if it's going to cost you something.
Yes, the bit that frustrates me about these things are really the time it takes for the rules to move from a press release to a document. And so I was looking as late as this morning on the New South Wales, because this is a New South Wales border closure.
Yes.
Not a Victorian border closure, so it's being run and administered out of New South Wales, so the rules will be in New South Wales, and we're waiting to see what those rules look like, and as late as 10 minutes ago, they're not yet available. All you can do is run from press releases as to what they actually mean, although we're 10 hours away from, midnight tonight they come in.
There's a landing page, but it just says more information will be coming.
Yes, I do note that if you are a person living in New South Wales and you visit Victoria, you have to isolate for 14 days when you go back. So simply allowing a postcode exemptions would appear to be more problems than anything else. Look, I feel really sorry for them. I feel particularly for the people in the towers. And I look at many of them and assume that many of them have left environments where there are, where there's the fear of intervention in the state in the way that you live. So and what people have been doing for them has been fantastic.
It is, and I guess that a lot of that outpouring of support has come because it did seem to be a police and a security intervention, and then a real slowness for the rest of it to follow. And I think no one's really criticising the lockdown. It's more the fact that it didn't come immediately with the sort of assistance that it needed to come with.
Yes, the nurses and medical staff didn't turn up as fast as the police did. Kind of thing.
No, not by a long shot. Actually, 1300 222 774 is the number if you have a question. Oh, yes.
And can I just do one last comment before we start taking some calls? I read the law reports regularly because it's part of my job, but every now and then you come across an interesting case that contains things that you hadn't turned your mind to. And the Victorian Supreme Court decided on Friday a decision between the operator of Yarra Trams and the people who put the signs on tram stops and wrap buses and do those sorts of things. So if anybody is interested to work out how much people get paid for advertising on tram stops, then the case is KDR Victoria against JC Decau.
Decau obviously being the advertisers. So it was a bit of a battle, was it, about
we
put up the poster, but who gets the money?
Yes, who's entitled to what proportion of the revenue generated?
And don't keep us in suspense, David. What was the breakup of revenue sharing?
Well, I think that there was an argument about, look, I really, to me, it was the fact that they were having the argument and you got to learn how much a tram stop was worth, for example, and whether it was a digital panel or a non-digital panel. So a tram stop with a static panel in year one was worth $1,101, and a tram stop with a digital unit were worth $320 a panel. So
there you go.
So they're interesting.
And look, I should just say before we start taking calls, because we did have calls on the open line about flight stopping and getting back into Victoria if you're already in New South Wales. I've got a statement here from Qantas and Jetstar. They have significantly reduced flights to and from Melbourne following the decision to close the border. They'll continue to operate limited flights for essential travel only. The reduced schedule will operate for most of July or the rest of July. And Sydney, Melbourne is most affected. Other routes are also affected. Routes like Melbourne to Ballina, which is Byron Bay. Impacted customers will be contacted about their options. Well, obviously not quite yet for some of them, but it does seem there will be limited flights. So I assume that people who are away, I hope people who are away can actually get back, particularly given schools are meant to be restarting next week. 1300 222 774. Anne in East Malvern, you kick off today. Good morning, Anne.
Good morning, Ali. Thanks, David. My question is to do with solar panels. In 2013, we installed solar panels on a north-facing roof, and our neighbours to the north, after that time, planted a line of trees, which have now grown up to impact on our panels. And I wondered what, if any, rights we have.
None. If the trees encroach into your airspace, you do, but and while the law at one stage recognised easements of light and air, they disappeared from the Property Law Act in the 1920s.
Ah, okay.
So the answer would be no. There's the fact that your solar panels aren't as efficient as they were when they were installed because of the trees. You have no redress.
Ah, what? And the same with losing the northern sun from the house.
Yes.
Yes.
Yes. Otherwise, there'd only be one house in the horizon, as it were.
Yep. Okay.
So no, I'm really very sorry, but
yes.
it's
so
and I'm not being unkind, but there's a planning term called NIMBY, which is not in my backyard, which means you can do whatever you like, provided I can't see it. And that's, if you look at planning cases, you find there's lots of people who say you're destroying the area, you're changing the amenity, you're doing all of those things. And it's you can do whatever you like, just don't do it near me.
But David, can I just ask about that airspace issue? If Anne's solar panels are being shaded by a tree and the bit of the tree that is shading the solar panels are on her side of the fence, She can chop them
Then
down,
she's
can't
got
she?
the right to. Then she can compel the neighbour to remove the overhanging branches.
Yep. It's just a question of whose side of the fence it's on.
Yes, it is.
And thank you, Gary in Melbourne. Good morning, Gary.
Hello, Ali and David. How are you?
Good.
Thanks.
Look, question, David, please, just regards how accurate minutes have to be kept at meetings. And if I could set the scene for you. I'm a small community sports club in the Greater Melbourne region. There's about 10 other clubs of different titles involved, which meet with a local government authority every 2 months, and the meeting is chaired by a contracted-in management group. Now, most of the clubs raise issues that, let's say, for example, under Rule 9.21.26, you must give us access and good use to the area at our allotted times. But quite often, and I'm talking about 90% of the time, the gates might be locked or in a state that you can't open them easy. The road through the gate you can't drive through, or piles of dirt and trees that they've chopped down are left blocking the areas and sites that we use. Then, when we get the minutes, the only thing that might be said in them is a member raised concerns about better access to the area.
Yes.
Is that okay, David, or do they need to go into greater detail?
It all depends on the circumstances. What you really need to do is keep accurate records of the decisions made and a summary of the process that you get there. You might, for example, if you really want to play a game, you might ask that something be read into the minutes. So you might produce 5 or 6 paragraphs and ask that it be tabled and that its contents be read into the minutes. That would make the minutes very long, but you would provide the minute taker with your copy of your document. And that's how you would get the detail in.
So you'd need to pre-table that with them, yes?
No, you could hand it up at the meeting, and you would need a resolution that it be read into the minutes.
Okay.
Gary, why is it important to you?
Just be careful you don't make too many enemies on the way through, though, Gary.
Well, Elliot, it seems to ruffle a few feathers that we expect accurate minutes to be kept, and they seem to really soften what actually happened there and the outcome, if any.
No, and that is why. I mean, that's why minutes are meant to be accurate and David, relatively detailed.
Yeah, there needs to be enough information about what's happened at the meeting that led to the resolution that was passed.
Gosh, you only have to.
You could table what you want to put to the meeting, and then that becomes part of the minutes.
You only have to look at recent experience with the Commonwealth Bank to see how people can majorly disagree on what really goes on in meetings, even though there are meant to be full and complete minutes of those said meetings. Marion in Glenlyon. Good morning, Marion. Good morning.
My question is regarding the question is it permissible for council employees to overturn a VCAT condition? It's regarding a proposed development, hotel development in our small town, which has no town water and no sewerage, and the proposed development sits above a very vulnerable environmental situation with natural springs running down into a natural spring-fed small lake. And the VCAT, a group of local residents have been very active.
You've opposed a permit application made by the developer.
What's that?
I take it you've opposed a permit application made by the developer.
The permit application was made to the council, and the elected councillors, voted to approve it on the condition that the only water that they could use was rainwater, harvested water.
Right, and then that matter then went to VCAT.
And then the matter went to, and that was after a lot of discussion in council. They had already installed a bore, which was
Marion,
which was ordered.
I'm a little bit cautious about how long your call's going to take.
Okay, then the matter went to VCAT, and the VCAT ruling also included that there was 3 days of most of the discussion was about environmental and water issues, including the member coming up and looking at the place. And the VCAT ruling also included no bore permissible on site,
So, Marion, what's your question to David? Sorry.
The question is that following the VCAT ruling, the owners of the property requested to council that the ruling that there be no bore allowed on site be overturned, and the council
Marion, if there is non-compliance with the VCAT conditions, the objectors can take it back to VCAT. All right?
So that's, Marion, I think that's where you're headed. I think you need to take that particular case back and obviously get that condition implemented. Ian in Bendigo. Good morning, Ian.
Oh, good morning. Hi, David and Ellie. Great show and very informative. I'm one of three landholders, one of which is a battle axe block with current access to a council laneway or right-of-way close to town, which has probably been in place for the best part of 100 years. A fourth landholder with its own street access on title and at the end of the right-of-way, which has no current access, wants to build a multi-unit development which includes accessing the right-of-way in order to manage traffic flow to and from their development on this fourth property. Who determines access to that right-of-way?
As a general proposition, it will be council. And right now, you see these from time to time, and you're talking about battle axe blocks, and every now and then you'll see people who share a common driveway to two battle axe blocks, and then one of the persons is quite happy with I'll call it a broad acre, low density occupation of the block, and the other person wants incredible intensification of use, and you have this argument that there's going to be 5 or 6 times as much traffic as there was ever planned to be at the time. Is that the kind of issue you're talking about?
That is the issue, and the current landholders that need access to that right-of-way, that is that they're only access to their garages or other, and there's going to be, probably a trebling of traffic in that right-of-way.
So your argument then, Ian, is that and it's a traffic engineering question, is whether or not the laneway has the capacity to take the extra through flow. So it's a council decision because it's a council laneway, but your argument would be that that's not sufficiently wide to be trafficable. I presume it's effectively one way?
It's actually two-way currently. They want to make their part on their land one way, and we still need to get in and out without crossing, their property to get into our garage.
Ian, you told me it was a council right-of-way, a laneway. Are you saying that this is an easement right, is it?
No, I don't think it's, I believe...
Because that makes a different proposition. And what you'd need to do is see exactly who's got what rights over the land, but if it is council land, then you would need to... then it would be council who would determine it. If it's an easement that you have to enjoy the crossing of their land to access your property, then what you're doing there is you're saying, they're not allowed to interfere with my rights. So you want to enforce your rights, and at that stage it's a property issue between you and the owner if they want to change or take away your rights.
Yeah, and I think we'll leave that one there. We might just move away from councils for a minute. Eddie in Altona. Good morning, Eddie.
Yes, good morning. Just had a slight query. I'll try and make it as quick as possible. My wife was given a gift voucher and got forgotten about, and under COVID, cleaning out some drawers, realised the gift voucher was due to expire, but because she'd just come back from overseas, she was in quarantine. And then when she came out of quarantine, the store she wanted to spend it in, which was Myers, was closed. She was unable to spend it. When they did open, the gift voucher had expired. Weren't able to use it. When I inquired with the issuer of the gift voucher, we were told there's no leeway and just refer to your terms and conditions.
Eddie, let's put that to David.
Eddie, I think that the ACCC has issued some statements in relation to gift cards in these circumstances. So have a look on their website. But as a matter of, how long was what was the life of the gift card?
It was 3 years. So
it was 3 years, and we've missed out in the last 3 months.
But it's still 3 months, though, isn't it?
No, I understand. I understand. Have a look at the ACCC. I would have thought that because we used to get lots of gift cards. Christmas was full of gift cards from record stores that were good for 12 months, or movie tickets that were good for 12 months.
So what does the ACCC say? You've got a case or you haven't got a case?
My recollection is they're talking about that people should be extending the validity of the gift cards.
Yeah, if you can't shop because your shop's shut.
Yes.
Yeah. Lucy in Mount Evelyn. Oh, Lucy, I feel for your daughter.
Thank you. Good morning, Ali and David. I'm just wondering, my daughter was due to get married in April, and when it was clear that the virus was going to affect that, she set another date, 8 September, and which was actually to be grand final day, so it was available. Now we're looking at having to postpone again. I'm just wondering whether there's a case for a frustration of contract in relation to the venue, caterers and other major suppliers in relation to this, because she's been told if she has to change the date again that she could lose her deposits or payments that are being made in full. And although she's been offered alternative dates by the venue, other suppliers aren't available. And I sort of feel that they've agreed to a fixed number, and consequently, with that fixed number, then if they have to reduce their numbers, then their contractual obligations aren't being met.
Payment obligation. Lucy, the problem I've got is that none of us know what it's going to be like in September. And I would have said that at this stage, an argument for frustration would fail, because it's not frustrated. You have to ask yourself exactly what's frustrated. Is it the wedding that's frustrated? Is it the reception that's frustrated? Or is it a reception with the bells and whistles that your daughter wanted for her wedding? Now, my view is that, there's clearly a huge difference between a wedding for 10 and a wedding for 100. But at this stage, your frustration argument just won't get up.
Was 3 weeks before the wedding, would it be a different sort of scenario?
No, if the government introduced, if the government extended the state of emergency and prohibited weddings in that particular postcode, then my argument would be there's a frustrating event. But the state of emergency is only being extended at 4 weeks at a time, because that's what the legislation requires.
Yeah.
And there's going to need to be, in my view, some legislation between now and September to change the legislation to extend the state of emergency options, because the end of September is beyond 6 months from the commencement of the state of emergency.
It is very hard for everyone, though, trying to make plans. Margaret Sorrento says in response, Lucy, to your daughter's situation, tell your daughter to elope. Save the money, save time. I eloped nearly 50 years ago and we're still married. Yeah, that's one option. But yeah, lots of people who have had plans change, including Paul in Doncaster. Paul, good morning.
Yes, good morning, Ali and David. I paid a deposit for a rail journey that was meant to happen on the 7th of June. Now, the terms and conditions when I booked stated that if the journey was cancelled by the operator for any reason, one of the options was a refund. Now, they say that the service wasn't cancelled but only suspended. But in my view, they can't supply me with a journey on the 7th of June in the future. So I'm wondering what you think about that.
Paul, the service was cancelled.
Yes.
It wasn't suspended. They're never going to do that run again. I'm not saying they won't run on the same line and the same crew and the same carriages, but it's like saying that I run the 8:05 flight from Melbourne to Brisbane at 4:15 and telling everybody it's the same flight. It's not the same flight.
The other point,
might have the same flight number. Sorry?
So the other point, David, is that there's a new set of conditions that started on the 1st of April where that clause now talks about a full refund or a credit note. But that
the contract, without having read the whole of the document, my view is that you're bound by the conditions that you signed.
Yes.
And my view is the service was cancelled. It wasn't suspended.
Paul, good luck. I mean, the travel issue is a huge one, isn't it, David? With
Yes.
the number of, you wait until the airline, the train company, the ferry company, whatever it is, does the cancellation, so you're not the one who cancels. But then, of course, because they're also worried about their own futures, they're very busy offering you a voucher first up, and you have to read the fine print to find any information about an actual refund.
Well, there was an article in The Age on the weekend in the traveller section that talked about Emirates would normally do 35, well, we're doing, I think it was 35,000 refunds a month, and then they're now at several 100,000 refunds a month. So they're not, their system's designed to take orders, not to give money back.
Yes, no, exactly. Thank you, David. Thank you very much. We hope that, well, maybe next week you'll be back in the studio with Virginia. We shall wait and see, but you stay well.
Thanks, Ali. Bye.
David Whiting there, Melbourne solicitor.